Good morning, Miss. My name is Chong Jia Hui.
Hi, I am Lim Kang Qing.
Lim Zi Tong.
Hi, I'm Jayson.
Hi Miss, my name is Song Lin.
Jia Hui. Today, my group members who are Lim Kang Qing, Lim Zi Tong, Jayson Lee, and Song Lin would like to present our case study from the topic of contract that we had learned about the misrepresentation happened by a company called Sinton Realty Sendirian Berhad versus the plaintiff called Tae Kim Da. This is about the facts or summary of the case. According to our research from website, in the case of Sinton Realty Sendirian Berhad versus Tae Kim Da, T. Kim in year 2003, 3 Malaya Law Journal 460, the defendant is a limited company, keep on acquiring land to build a factory. The land in question was owned by the plaintiff. A representation was made by the estate agent that the land had access to the main road, a fact that was later discovered to be untrue. In this way, the defendant refused to complete the agreement on this ground, and the plaintiff brought an action claiming that the defendant had repudiated the sales and purchase agreement. The defendant defended the action on the ground that the agreement had been vitiated by the agent's misrepresentation. Apart from that, the court held that the defendant is entitled only to rescission and to the return of the deposits of 254,204 ringgit, but not to the interest on such sum. This is because awarding interest could amount to compensating the defendant for the loss of the use of his money while it was in the plaintiff's hands, and this could amount to damage.
The legal issue discussed by the case. The issue is, can the defendant defended the action on the ground that the agreement has been violated by the agent misrepresentation. In the case of Sinton Realty Sendirian Berhad versus Tae Kim Da, the defendant is the limited company on acquiring land to build a factory. The land in question was owned by the plaintiff. A misrepresentation was made by the estate agent that the land had access to the main road, a fact that was later discovered to be untrue. The defendant refused to complete the agreement on this ground, and the plaintiff brought an action claiming that the defendant had repudiated sale and purchase agreement. Under Section 18 Contract in 1950, misrepresentations includes the proceeded assertion in a manner not warranted by the information of the person making it, or that this is not true, thought he believed it to be true. Any branch of duty without an intent to deceive, give an advantage to the person committing it or anyone claiming under him, by misleading another through his prejudice or the prejudice of anyone claiming under him, and causing however innocently a party to an agreement to make a mistake as the substance of the thing which is the subject to the agreement.
So here is the outcome of the case. A representative who has been induced by an innocent representation may sue for rescission and consequent restitution, but he may not recover any damages. This principle is based on the historical antecedent that a court of equity will only decree specific relief but not damages, the latter being the sole relief that court of common law will grant. From a commercial perspective, some salesperson may make certain promises or representation to procure an agreement to a contract, and as such, some contracting parties may be left with less than what was bargained for. This is where the court will step in to do justice for the injured party by applying the equitable remedy of rescission which balance the right of the representative and the representee. Thank you.
Would like to talk about argument of the case. From the case, on the one hand, the plaintiff wants to enforce the agreement. On the other hand, the defendant tried to avoid entering into an agreement by making false statements. So, the lower court have to decide whether an actionable misstatement has been made based on the evidence. If it is, then the agreement will have to be set aside unless any facts exist, and the discretion will be exercised against the granting of equitable relief. If not, then the agreement will be very effective and the defendant will be obligated to honor its term. Therefore, in my opinion, with all due respect, I disagree with the learned judge approach. Once the learned judge finds that the plaintiff has made a statement about availability, it is his duty to proceed and determine whether this constitutes an actionable misrepresentation. In fact, this is a major case brought by the defendant. The judge has a duty to deal with the problem out of respect. The learned judge, however, for reasons not stated in his judgment, completely ignored the case put forward by the accusers and the question it raised. Instead, he argued that the issues raised by the plaintiff were the only ones that needed to decide. Accordingly, the defendant was excluded from the plea request by the plaintiff and did not stand trial. This violates the basic rules of procedural justice, which require that a party raising a question of substance, whether in support of his or her claim or for the defense, be entitled to an opinion from the court.
The case looking one was seemingly very reasonable. The plaintiff purchased a double-story bungalow house from the defendant according to the terms of the sales and purchase agreement. An agreement had signed between the parties. The area mentioned clearly with the area had shown in the issue document of title. The defendant, as the development, had transferred the same area of land to the plaintiff. Subsequent to the commencement of this possessive investment, had land to show that the plaintiff had resold the double-story bungalow house and transferred the land to the new buyer at a much higher price, and the area had shown turned out to be the same as start in the sales and purchase agreement entered into between the plaintiff and the defendant. In this similar case, damage subject to proposed pending and flow could be claimed for breach of contract, but in the absence of fault nor negligence, there could not be damage for innocent misrepresentation if neither negligence nor fraud was alleged with the alleged relative particular. Just like the present case at hand, then the alleged misrepresentation were an innocent misrepresentation, and it did not attract any award of damage. There was not best for the plan of transport. The unchallenged and disappeared evidence would be that the firm was erected by the defendant contractor. When the defendant was still the registered owner of the land, plaintiff have admitted that the firm was put out before the sale to the plaintiff. Since the land has been transferred to the plaintiff, the defendant was unable to enter the land and demolish the firm at will. However, in the case of symptom related behavior Tam Tae Kim Dan, the judge did not pay more attention to the present issue, but it did not show the misunderstanding raised by the defendant too much. Many evidence of interest are based toward the defendant. So compared to the two cases, the case of symptom relative Senebahad is a bit sloppy. The judge only focused on the mispresentation about the access to the land. Thank you.